Good afternoon, Your Honours. This is case number IT 0142I, the prosecutor versus Vladimir Kovačević.
Thank you, Madam Registrar. Mr. Kovačević, can you hear me in a language you understand? Is Mr. Kovačević on the right channel?
Mogu da vas pratim.
Yes, I can hear you, Your Honor.
Thank you, Mr. Kovačević. May I have the appearances? Prosecution first.
Thank you, Your Honor. For the prosecution, Susan L. Summers. To my right, Mr. Philip Weiner. To my left, Miss Victoria McCreath.
Thank you, Ms. Summers. And for the defense, please.
Your Honor, Howard Morrison.
Thank you, Mr. Morrison. The first thing this trial chamber has to do at an initial appearance, Mr. Kovačević, is to satisfy itself that your right to be assisted by counsel is respected. I see that you are assisted by Mr. Morrison. Is this in accordance with your wish at this moment to be assisted by Mr. Morrison?
Yes.
Mr. Kovačević, this initial appearance mainly serves to confront you with the charges against you and to hear from you whether you want to enter a plea on those charges either within the next 30 days or today. May I first ask you whether you received a copy of the indictment that was brought against you in a language you could read?
Yes.
Have you discussed the content of the indictment with counsel? I do not hear any translation at this moment, but from the original, I understand that the answer was in the negative. Mr. Morrison, could you...
That's correct, and it's for this reason. There is a potential supervening problem in this case as to whether or not the accused is a person who is fit to plead to the indictment. So that's the matter which is causing, at the moment, the greatest concern to the defence. I have a copy and have read the indictment, as indeed has the accused, so we both know what's in the indictment. It's not a question of what's in the indictment at the moment, it's his capacity to enter an informed plea that's in issue.
Yes.
So that's the reason why we haven't discussed the details of the indictment.
Yes, I do understand, Mr. Morrison. This chamber, as you may have noticed from the fact that this initial appearance has been delayed, has received some documents in relation to the health of Mr. Kovačević. The last information, written information we received, dates from last Friday, I think, and the last information we received oral information was given to us today. Could you give us any, from what you say, Mr. Morrison, I do understand that the chamber would not even ask the accused whether he could enter a plea and rather at this moment limits itself to confronting the accused with the indictment as such. Is it your opinion that Mr. Kovačević is capable of listening to the charges brought against him today so that he can consider over the next 30 days, as the rules say, whether or not to enter a plea? I mean, is it of any use to read the indictment today to him, or do you say, well, he wouldn't understand it anyhow.
Your Honour, there is no question about his intellect. He can certainly read, as I understand it, and understand the words in the indictment. It's not reading the words of the indictment or understanding their literal meaning which is the problem. It's whether or not he has a sufficient mental capacity to be fit to plead to it and thereafter to stand trial. So, as I understand it, obviously speaking as a layman and not a psychiatrist, there is nothing, there'll be no value today, in fact, in reading the indictment out to him, because he wouldn't. I would urge you not to arraign him so that he wasn't going to enter a plea today. The question of the next 30 days is clearly the issue which needs to be determined, what happens between now and the expiration of 30 days. And what I'm going to ask the trial chamber to do is to order expedited psychiatric reports. I say expedited because I know my own experience in my own jurisdiction is that it usually takes a great deal longer than 30 days to get a full psychiatric report, unless the court orders an expedited report. And it is usual to have 2 reports from 2 separate psychiatrists to see whether or not there is a coincidence of professional opinion or whether there's a divergence of opinion. One can discover that at an early stage by having 2 reports. And I think that would be the most useful exercise that we could undertake, subject, of course, to the court agreeing with my submission. Plainly, it would assist if the psychiatrists were able to speak to the accused in a language which he understands, rather than having the additional problem of anything coming through in translation. I appreciate that adds rather than detracts from the problem, but I'm sure there must be available to the tribunal such expertise.
Yes. Are you aware, Mr. Morrison, of the last written report the Chamber has received?
No.
Then perhaps would you prefer to deal with it in closed session rather than an open session, or it concerns the psychological aspects of the health, or the psychiatric aspects? Not necessarily. I mean, it has been clear to the public that there are some problems, but if it comes to details, I leave it up to you and Mr. Kovačević whether you apply for closed session to deal with it.
My instinct, without taking instructions in the matter, is to ask for a closed session, because I haven't seen the document, and
yes.
I would be hostage to fortune to do anything else. I'm sure Mr. Kovačević has heard what I've said in translation, that it's my suggestion that we go into closed session, i.e., in case he doesn't understand what that means, an element of privacy, and perhaps he can indicate what his views are.
Yes. Apart from that, private session would perhaps also do, because it's rather a matter of the spoken words than to have the curtains down.
Yeah.
Mr. Kovačević, Mr. Morrison thinks that you'd prefer to discuss your psychiatric health not with the public hearing whatever has been said, but to put the microphones off as far as the outside world is concerned. I do understand from your nodding that you agree with that, but before giving any decision, that Ms. Summers, would you please express the position of the prosecution on both points? The first one is that it would not even be of any use to read the indictment to the accused today, and the second one is whether or not to go into closed session in order to discuss the health situation of the accused.
Your Honor, inasmuch as we are not in closed session at this moment, I would simply indicate that the prosecution is also not aware of anything more current than the 27th of October. And so I would be very grateful to see the most recent, or hear about the most recent assessment. And based on prior reports, it was our understanding that perhaps proceeding might be possible. Accordingly, I'd have to leave it in the Chamber's hands to let us have a look.
Yes. Perhaps then we turn into private session in order to discuss the latest reports on the health. Mr. Kovačević, the Chamber has understood that you have medical problems at this moment, and that therefore it's not sure that it's of value for yourself, for any use to yourself, to have the indictment read to you. But this initial appearance has several functions. One of them to inform you about the indictment, but also to inform the public about the case. Therefore, I'll briefly explain to you what this case is about. The charges brought against you concern the events that happened on the 6th of December 1992 at Dubrovnik. On that day, an attack was launched, according to the indictment, against the city of Dubrovnik, and you are specifically charged with your participation in that attack, an attack that, according to the indictment, resulted in the death of 2 persons and in 3 persons injured, and an attack which caused considerable damage and devastation that was not caused by military necessity of civilian objects, and specifically also it caused destruction and damage done to institutions dedicated to religion, charity, education, arts and sciences, and historical monuments, and finally also works of art. Your participation in the indictment is one which entails your criminal responsibility, either by direct participation or because you were held responsible because of your command position. That is in short, so your participation in what happened on the 6th of December 1991 in Dubrovnik, causing death, injury and damage. I'm not going to ask you today whether you whether you want to enter a plea or not. The Chamber will first consider whether it's necessary to have a psychiatric examination done. The rules say that an accused enters a plea within 30 days, but they can do it right away. I'll not invite you to do it right away. You'll be asked to do so at a later stage, if at least the Chamber is of the opinion that you are fit to enter a plea. For the public, I'll briefly read in what counts the events are legally formulated. Count 1 is murder, a violation of the laws or customs of war, as recognized by Common Article 3(1)(a) of the Geneva Conventions of 1949, punishable under Article 3 and 7(1) and 7(3) of the Statute of the Tribunal. Count 2, cruel treatment, that relates to people injured. Cruel treatment, a violation of the laws or customs of war, as recognized by Common Article 3(1)(a) of the Geneva Conventions of 1949, punishable under Article 3 and 7(1) and 7(3) of the Statute of the Tribunal. Third count is attacks on civilians, a violation of the laws or customs of war, as recognized by Article 51 of the Additional Protocol 1 and Article 13 of the Additional Protocol 2 to the Geneva Conventions of 1949, punishable under Articles 3 and 7(1) and 7(3) of the Statute of the Tribunal. As far as the damage done to objects is concerned, the attack on the 6th of December 1991 on the city of Dubrovnik amounts, in the opinion of the Office of the Prosecutor in Count 4, devastation not justified by military necessity, a violation of the law and customs of war, punishable under Article 3(b) and 7(1) and 7(3) of the Statute of the Tribunal. Count 5, unlawful attacks on civilian objects, a violation of the laws or customs of war, as recognized by Article 52 of Additional Protocol 1 to the Geneva Conventions of 1949 and customary law, punishable under Article 3 and 7(1) and 7(3) of the Statute of the Tribunal. And finally, it amounts in Count 6 to destruction or willful damage done to institutions dedicated to religion, charity, and education, the arts and sciences, historic monuments and works of art and science, which is a violation of the laws or customs of war, punishable under Article 3(d) and 7(1) and 7(3) of the Statute of the Tribunal. Attached to the indictment is one annex which deals with the overall military structure of the forces involved in the attack as described in the indictment, and a second schedule which is a list of approximately 50 pages describing in detail the damages to the institutions dedicated to religion, charity and education, arts and sciences, historic monuments and works of art in the old town of Dubrovnik. Mr. Kovačević, before we adjourn and before the Chamber will deliberate on the questions raised by Defense Counsel on whether you're fit to enter a plea, I'd like to ask you and the prosecution whether there's any other issue to be discussed at this very moment. Mr. Morrison. And I'm specifically thinking of detention situation, which is often one of the issues accused want to raise during the initial appearance.
The instructions I have to date are that the accused is suffering, in addition to whatever psychiatric illness he may have, from a sense of claustrophobia, of being contained within the detention unit. That may or may not be part of the general psychiatric picture. I'm not qualified to say, but he certainly has specifically talked of the claustrophobic effect of that. And indeed, that became apparent when we were together in a small room in the detention centre. It was plain that without the door being left open, he was very uncomfortable. That was observable by myself. That, of course, has inevitably a knock-on effect. The sense of claustrophobia leads in itself to a sense of unease and distress, again, which is, one doesn't need to be a psychiatrist or a doctor to see that as a matter of common observation. And those are matters which not only which I've observed, and I'm not entitled to give evidence, but those are the matters which are apparent from just seeing the accused and about which he complains himself. And that's caused, amongst other things, a loss of appetite. And he's generally, if I can put it in very lay language, he appears to be physically less well than he should be. But that may be as a result of the psychiatric problems rather than any clinical physical problem which he has. Apart from that, he appears to have been, as all new detainees are, in a state of shock because of the transfer of lifestyle. That's something that the court will see in almost every case. He has not asked me to deal with any other specific issue, but of course I know that the tribunal will make inquiries of him directly as to that. But those are the sort of broad observations resulting from what my instructions are.
Thank you, Mr. Morrison. Mr. Kovačević, is there anything you'd like to add to what your counsel has submitted to the chamber at this moment?
Moj brandilac je
My counsel has noticed very well the condition I'm in. My late brother also came into a situation similar to mine today, and he committed suicide. I hope that I will not do that. But I really find it hard in such a small room, even though the staff are very correct and they've opened a small window for me. There's a small gym close by, and I spend most of my time there. I shall, of course, try to adjust to the group and requirements of the group. I'm trying to prevail as much as I can. I don't know for how long I'll be able to. Even before this, I was in detention for about a month in much worse conditions in terms of comfort. But something seems to be affecting me more here. I don't exactly know what it is. I'll do my best, but I don't know for how long I shall manage. I'm losing my appetite, and I really feel unwell. So I was better prepared last Friday to appear here, but in the meantime, they had already postponed it. So I don't know. I'll consult with doctors and psychiatrists, and we'll see. I'm speaking to you quite frankly and objectively. My defense counsel himself has noticed some things that I didn't ask him to present here. That's all I have to say.
Thank you, Mr. Kovačević. Ms. Summers, is there any issue to be discussed at this moment, or would you like to respond to what has been said until now?
Your Honor, I will reserve certain comments until other matters that the Chamber has just addressed are known to the parties. But I will say that it is not a unique comment by this accused that confinement does not necessarily suit him or her, and accordingly I don't take any particular concern at that comment in that context, but only in that context. What I would just raise is that this accused is not alone as the accused in the case, and whatever is decided by this chamber will have a direct impact on the co-accused, Strugar, whose case we must also address, and accordingly I think that timetable should be very much borne in mind, because it has already been set back by circumstances.
Yes, the Chamber is fully aware of I would say that the cases are this moment still one case, or at least two cases, but they're not severed. They're still joint cases. Whether that remains or not is another matter. We'll have to see how matters develop. But the Chamber is certainly aware of that. Is there anything else to be raised?
I would only add, if the Chamber would permit me, that the prosecution, should we have gone forward with the first appearance plea or entry of plea, the prosecution is prepared to submit supporting materials as is required under 66A1. At this point in time, I believe we will certainly have to wait, but we've made it clear to Mr. Morrison that should he continue, that we have the materials for him, and we are very happy to meet with him.
Yes, let me just have for one moment look to yes, when I read 66A, Ms. Summers, I read that the disclosure should take place within 30 days of the initial appearance. It does not say that disclosure should take place within 30 days after a plea entered by the accused. And the rules provide clearly that at the initial appearance, the accused should be informed that he will be called to enter a plea within 30 days. And therefore, I'd like to know from you whether you interpret Rule 66 such that the 30 days only start counting on from the moment that the accused has entered his plea, or whether these 30 days start off today.
I think the principal purpose of the first appearance is to enter a plea, and although it may be left somewhat vague, I would submit to the Chamber that the purpose of it is from the date of pleading. 30 days would be triggered. I would be willing and happy to check any existing jurisprudence on this point, but given two facts, one of which is matters that were discussed both in public and in closed session, and given the fact that we are not clear about the position of counsel at this point in time, to deliver materials with no guarantee of safeguard, not from counsel. Counsel has agreed certainly very responsibly to handle them, but if there is a period where there is some hiatus or change, we'd like to be sure that the materials, which are deemed, of course, confidential, are with the parties that will ultimately handle the case if the Chamber so agrees. But I would submit that it would be from the date of plea. Again, if the Chamber would like to take a recess, I can check jurisprudence and see how it has been determined, but at this point, that would be my submission.
Yes, perhaps it's not completely necessary that the decision will be taken right away. But may I ask you the following question? Would you consider that disclosure copies of the supporting material would also assist the accused in making up his mind as how to plead?
I believe the Chamber is not clear if the accused is in a position to do so at this point in time, so it may be a bit of a circle. So perhaps from the point in time where that is determined and a plea is entered, it might be more helpful, given the dialogue that has just taken place both in public and in closed sessions.
Mr. Morrison, any submissions in respect of this issue?
Well, Your Honour, with respect, I see the common sense force in the prosecution's position in respect to those matters. It's, in an ideal world, the sooner the accused has sight of the material that he has to face, the better. And perhaps this is a matter that when the Chamber, essentially the question of disclosure material is subject to two things. First of all, an independent decision taken by the prosecutor as to when to disclose it within the certain time frame, or secondly by virtue of an order of the court. And it may well be that whilst Your Honours are in recess determining the matters that you have to determine, I can have a word with my learned friend and we can come to what happens in English politics all the time. It's a good old-fashioned compromise.
Can I ask the Chamber for one more? Thank you very much.
Yes, please, Ms. Summers.
Thank you, Your Honor. One of the issues, of course, is what is triggered by turning over the materials, which is the Rule 72 motions, the time for them. That if the Chamber wishes that we, or orders that we turn them over today, we would, of course, ask that the time begin to run also for those motions if that is going to be an issue. And it's hard to separate the two. So I just ask the Chamber to factor in the linked issues to the turning over of materials, again, which are ready to be turned over.
Yes, if you consider that Rule 72 reads that preliminary motions shall be in writing and be brought no later than 30 days after disclosure by the prosecutor to the defence of all material and statements referred to in Article 66A1. Mr. Morrison.
Well, of course, that is a determining factor. And it may be that in this case, again, out of an abundance of caution and out of the fact that I'm only counsel assigned for the present on a temporary basis, it would be better to respect the problems that the Rule 72 time limits might generate, not to make an order for disclosure today. In other words, to treat the order for disclosure under as running from the time of arraignment rather than the time of initial appearance.
Yes, I do understand. The Chamber will consider whatever has been submitted today. Will give whatever orders or decisions appropriate, but will first deliberate on all the issues raised today. And the Chamber takes it that the parties will continue to have their meetings and to communicate with each other in order to solve whatever problems they can solve themselves, and the Chamber would very much like to be informed about whatever progress has been made in this respect. Yes. Mr. The final thing I'll then do is to inform the parties and tell you, Mr. Kovačević, that at least within 30 days there'll be another hearing, whatever will be discussed at that moment, but it might be that you're then called to enter a plea, but it depends very much on the decisions still to be taken by this Chamber, but you'll appear again in this court soon. We'll adjourn until a date not yet fixed.
All right. Feu vous levez.